Hello friends, hi, hope you all are doing good. In this particular module, we are going to discuss certain recent judgments as well as recent updates from the tax perspective. Before that, given that but we are specifically in this particular tough time of due to this COVID-19, there is something which I would wanted to share with you. It's more than around a 12 months or so of this unhealthy comfort eating, disrupted exercise routine, doom scrolling through social media, uh, and all this have made us anxious as how we look, how are we doing, and on so many aspects of life, and we are nowhere able to compare ourselves about how the things are happening at a global level or at a compete level. So it becomes necessary that we maintain a healthy lifestyle, and it is a time for us for banishing our insecurities and to enhance our self-image. So this is something which I wanted to tell my friends that this 6 months you can focus on all this particular stream to enhance your confidence, to build much more strength into your core domains, and this is something which actually helps in taking us at places as well as enhancing our self-confidence. uh, Let us now come again to our tax topic. From tax update perspective, what I actually wanted to cover is that from first of all, we have an update on Section 269 ST. Section 269 ST of the Act, which says that if you have made a payment of a specified sum of more than rupees 2 lakh per day for a particular transaction, is such transaction should be prohibited, and there is again a penal implications on this. However, considering this COVID situation, the government has recently issued a notification exempting COVID facilities such as hospitals, dispensaries, COVID care centers, if you are able to provide PAN or Aadhaar of the person making payment as well as of the patient. And this particular payment should be between 1st April 2021 to 31st March 2021. Uh, Besides this, there are two provisions. There are two relevant investors category who are provided tax exemption as well as taxation at a relaxation rate if they fall under section 10 subsection 23 FE, which being a sovereign wealth fund as well as pension fund. So recently, government has by way of notification notified 5 SWFs as well as 4 pension funds. There are few more pension funds who were also prescribed in the recent past as well. Besides this, the Central Board of Direct Taxes has issued procedures as well as forms as well as guidelines for reporting SFT transactions for mutual funds as well as depositories. Uh, One critical amendment over here now again is that for SCP, for SCP, as you may know that Section 9 of the Income Tax Act says that any income shall be deemed to accrue or arise directly or indirectly if it is from a business connection, from a capital asset, from a property in India. There are explanation 2A to which says that business connection can also include SCP, and the definition of SCP are again for two clauses A and B. If you are falling under the clause A, it says if that you are making payment in exceeding the notified amount for goods, services, or property, uh, or for download of data or software by a non-resident to a person resident in India. So they have notified the amount, and this particular amount is 2 crores. On the second point, you can also be considered to have a SCP or a business, therefore a business connection in India, if there are number of users exceeds a specific limit, and this particular number of users for soliciting business or for conducting business is now 3 lakh users if the business is through a digital means. Uh, Besides this, there has been also an update that a person is generally required to obtain a PAN in India. However, there is a relaxation which is now provided to an eligible foreign investor. An eligible foreign investor is a person who has made investments in the securities which are exempt under section 47, and for which are investments are in for convertible foreign exchange in the IFSC in India. So this is a specific relaxation to further enhance liquidity in the gift city. Besides this, there was certain relaxation which was also provided to your category 1 as well as to the category 2 AIFs. Now they from a requirement of obtaining PAN to the investors of the category 1 and category 2 AIFs. Now they have widened this particular relaxation to also include any specified fund, which therefore also would include category 3 AIF. So this was something from a general update perspective. I would also now focus on the updates that we have from a taxation perspective from judgments. So we all have now this faceless assessment regime has initiated, and generally AY 2017-18 as well as AY 2018-19 are currently undergoing. Even the due dates for passing of the assessment order in most of the cases is again relaxed considering this COVID situation. But in this faceless assessment scheme, we are now seeing that there are several orders which are passed by the under the faceless assessment scheme by the Faceless e-assessment center. However, this particular order are lacking in terms of the way in which the order are passed. Say for this particular case in the Madras High Court, a petition after receiving of the final assessment order, the taxpayer had filed a writ petition, and the taxpayer being Magic Words Exports Private Limited. And what was this particular case? There was a show cause notice as well as a draft assessment order which was issued by the National E-Assessment Center. Against this show cause notice, the taxpayer had filed as for an adjournment. But before the adjournment date, only the National E-Assessment Center had passed the assessment order, final assessment order under section 143.3. So in this case, because his request for adjournment was not as such entertained, or he was not given an adequate time, he filed an appeal against this particular final order for putting this particular order in abeyance. So considering the discrepancy in the particular case involved, our High Court had directed the CBDT to enable him to submit his response in this system, as well as the taxpayer is also granted a relief by the High Court that he can make his submission within the period of 3 weeks. So this is the specific direction which is given to file a response within 3 weeks and to enable submission. Besides this, there are a couple of judgments on DDT refund perspective. There's a long going litigation, not litigation, but a view which is prevalent in the market and largely adopted as well. That DDT, let's say, is collected at the rate of 17 point something. However, if let's say the tax rate is 15% or 10%, then the excess DDT, which is on applying the blanket rate, which is reduced by company, can an Indian company claim a refund of that particular DDT amount? So the first case is in the case of IDT cementation, which is of the Mumbai Tribunal, and in the case of India-Thailand Treaty, where the tax rate is of 15%. There is again one more judgment which came in the context of India Oil Petroleum, being an Indian company who had applied for DDT refund, more so by applying an additional ground during the course of assessment appellant proceedings, and this is in the context of the India-Malaysia tax treaty. So again, in the context of tax on dividend, as you may say that because this is a tax on dividend is an additional tax collected under the Indian tax law. This particular income is chargeable under section 4 of the Act, and only because of the administrative convenience that the government has adopted the strategy of collecting tax directly from the Indian company distributing the dividend and not collect it from the final recipient of income, just so that they can avoid any incidents of tax avoidance. So it is only for the administrative convenience that this particular tax is passed on to the Indian company and not collected from the person who is the recipient of the income. The Supreme Court in the case of Tata Tea as well as in the Godrej also held in Godrej from section 14A perspective as well as in Tata Tea from section 10 perspective had said that your taxation on dividend income is again your tax on your income. So applying this particular judgments as well as other tribunal judgments being of the Delhi Tribunal, the particular tribunal being Mumbai Tribunal in case of IDT as well as Kolkata Tribunal in the case of India Oil Petroleum, have directed the tax officer for refund of the excess TDT to the Indian company. Uh, there are a couple of very interesting judgments. I would come upon this Interworld Shipping LLC later on, first focusing on WNS Aviva. This both the judgments are pronounced by our favorite sir, which is Pramod Kumar sir. In the WNS Aviva case, there's an interesting proposition to say. A transaction of the merger took place in 2008. So there is this WNS Jersey entity which is investing in WNS Mauritius, which has made further investments in WNS Capital Investments Mauritius. This WNS Capital Investment Mauritius also owns an Indian company, WNS Global Services Limited. Okay, that's one structure. There's an Aviva group entity. There's an Aviva UK, who is holding shares in Aviva Singapore. And this Aviva Singapore has also two Indian companies, A and B. In 2008, these two first of all, WNS Capital Investments purchased the shares of this Singapore company and paid consideration to Aviva UK. Because this particular company is deriving its value from companies which are in India, the transaction was as such applying the retrospective law considered as indirect transfer of shares. And considering this as an indirect transfer of shares, considering this to be an indirect transfer of shares, the tax office had therefore tried to levy indirect transfer taxation. However, it is also pertinent to note that these two companies got merged with the Indian company of the WNS Group entity pursuant to merger. However, the courts are aware of the view that these particular transactions have been taken place only for tax avoidance perspective, and more so, they levied the tax officer levied withholding obligation on the WNS Capital Investments so as to deduct tax on this particular income. Please note the transaction took place in 2008. Indirect transfer provisions from retrospective effect were introduced in this statute in the year 2012. So, is it possible, if there is no provision in the statute to deduct tax, would by any way a person who is not aware of the statute that could be introduced in a future date directly reduce tax? Answer will be no, obviously. So this is what is called as impossibility of performance. So considering the doctrine of impossibility of performance, which is even laid down by the Delhi High Court in the case of NGC Network, by the Bombay High Court in the case of NGC Network, there was considered that there is that it cannot be possible to deduct tax as there is a doctrine of impossibility. Besides this, it should be noted that the tax withholding provision should be dealt in a different manner and not in the same manner you deal with the normal tax provisions, as the context of withholding is completely different. The Supreme Court had also applied the tribunal also applied the rationale which was derived from the Supreme Court in the case of Engineering Analysis Center of Excellence. And what I want to focus over here again is in this context of impossibility of performance, the court has applied the principle of lex non cognit in impossibilia. The law does not demand that the impossible impossible can be done. When there is disability that makes it impossible to obey the law, the alleged disobedience of law is excused. And observe that when a law is nowhere even on the horizon, indirect transfer is not in the horizon, leave aside in the statute, it is wholly impossible for any person to perform the obligations imposed by such law. So when applying these particular principles of impossibility, as well as also focusing on the thing that the Aviva group, being a seller, had paid taxes on the sale of this particular shares. So considering this in mind, the court had the tribunal, considering all this holistic picture, the tribunal was of the view that the interest as well as withholding should not apply, considering that there is impossibility of the performance. As I told you that I would again come on the other judgment, which is again pronounced by the Mumbai Tribunal in the case of a shipping company which is based in UAE. So the tax officer had challenged residency of the UAE and therefore the treaty eligibility of this UAE company. First of all, the tax officer was of view that it is a partnership firm and not an not a UAE company. However, it was substantially submitted by the SSE that it is a limited liability company and not a partnership firm per se. The tax officer noted that 80% of profit of the SSE entity was to go through a Greek national, and he alleged that this particular Greek national is in UAE only to claim the benefits of the India-UAE tax treaty. That since this person was a Greek national, one second. The tax officer alleged that because this particular national is a Greek national, it could be safely be concluded that the business was not managed or controlled from the UAE. It was also noted that SSE company is a partnership firm, which I said was a wrong observation. The tax officer further said that treaty just having a tax residency certificate cannot be considered as a sufficient proof, as it is only a necessary proof. Pertinent to note that what is the residency criteria as per the India-UAE tax treaty for a company. A company is a company which is incorporated in UAE and is managed and controlled wholly in UAE is considered as a tax resident of UAE. So the SSE company has 14 expatriate employees, 14 employees. So it is functional. It also means that there is an office in UAE. Then this Mr. Gentleman, who is of Greek national, was also there in UAE for around 300 days, and all this was duly supported by entry-exit passports. So considering all this in mind, the tribunal said that when a person has a resident permit of UAE and the company no question is incorporated in UAE and is doing business from UAE, there is no reason to doubt the position that a business is carried out in UAE. And huge focus was given that the director of this particular country was therein for around 300 days or so. So over here, the tribunal had a good observation which should be noted. For the requirement of presence in UAE for 183 days for resident status under Indian UK tax treaty is for individual and not for the directors of the company who claim such residential status. As for the companies, the only test for company being termed as resident is that they have to be incorporated in UAE and wholly managed and controlled in UAE. And because you have an office, you have an establishment since 2000, you have an expatriate employees working over there, one can say that you are considered to be a resident of UAE. Now, the tribunal also had applied a limitation of benefit clause for not for terming that the entity is for claiming treaty benefit only. So it is pertinent to note this particular observation of the tribunal. An entity which is a resident of contracting state shall not be entitled to the benefit of agreement if main purpose or one of the main purpose of the creation of such entity was to obtain the benefit and agreement which was not otherwise available. What is the purpose or main purpose of one purpose of creation of entity? The entity in this particular case was created in 2000 and not only at the time when this particular business which was started from UAE in 2015 for the year which was under litigation. So because the entity was already since there in 2000 and not in 2000, not just created in 2015, it can never be said that the reason for creation of entity was only to claim this particular treaty benefit. So I guess or I hope that you like this particular video. Do let me know if you require any clarification or you have or you want to know any specific judgments or any recent updates. Thank you friends. Have a great day. Stay at home. Stay